Legal Aid Informational Video Series Part 3: Familial Status and Hanai Relationships. Scenario 1: Hanai Relationships and Legal Documentation. Last month, baby Ka'imi moved in with his grandparents after he lost both parents in a tragic car accident. Since baby Ka'imi moved in, Grandma Jo and Grandpa Rick have been experiencing issues with their landlord Lonnie. A few weeks ago, Lonnie recently gave a notice to grandparents which told him that they were in violation of their lease because they have an additional tenant, baby Ka'imi, and Lonnie did not approve of this before he moved in. Additionally, landlord Lonnie threatened to evict grandparents if they do not provide legal documentation showing that they have custody of baby Ka'imi. Grandparents explained they are Ka'imi's only surviving relatives. They consider him as their own, Hanai, and cannot afford to go through the family court process at this time. Can landlord Lonnie require permission and/or require legal documentation in order for a minor child to live in the home? No. Hanai's status is unique to Hawaiian culture. Hawaii law recognizes Hanai status, which means that parents, custodians, legal guardians, etc., are not required to provide a landlord legal documentation regarding custody, adoption, or guardianship. Here, if landlord tries to evict grandparents from the unit, she will be discriminating on the basis of familial status Hanai relationship. Scenario 2: Hanai relationships with additional fees for a child. After speaking with her friend, landlord Lonnie decided that she will allow grandparents and baby Ka'imi to continue living in their unit. Lonnie, however, began charging an extra $150 a month for baby Ka'imi. Grandparents asked landlord Lonnie why they were being charged an additional amount than what is on their current lease. Landlord Lonnie replied, "I'm letting baby Ka'imi stay, but since it's an extra person, you gotta pay more." Grandparents are on a fixed income and are afraid that they cannot afford this long term. Can landlord Lonnie charge an additional fee for baby Ka'imi? No. Charging an additional fee for a family member is a violation of state and federal fair housing law. Scenario 3: Familial status, noise complaints. Grandparents and baby Ka'imi continue to live in the same unit. Recently, landlord Lonnie gave a notice to grandparents regarding noise complaints she received from neighbors. Landlord Lonnie said, "Your neighbors don't like hearing the baby cry. If you can't control Ka'imi's crying as soon as possible, you will need to move somewhere else." Scared of eviction, grandparents scramble to look for alternative housing. Did landlord Lonnie violate fair housing law? Yes. There is a difference between noise complaints and complaints relating to a baby. Threatening to evict simply because a baby is crying is a violation of the Fair Housing Act and is familial status discrimination. If you believe you have been a victim of housing discrimination, you can contact the Legal Aid Society of Hawaii at 808-536-4302 to determine if you qualify for legal assistance.